Namaskar. In this video, we will be talking about the legal and practical aspects that a Hindu needs to consider while drafting his will. There are some queries that are in mind of several people. This video seeks to answer those queries. The most frequently asked question is, do I need to prepare my will on a stamp paper? The answer is no. Your will can be prepared on a plain piece of paper and that would still be a legal and valid will. Another question is that, do I need to register my will? No, the will is not compulsory registrable. Indian Registration Act Section 18, which enumerate the documents that may be registered at the option of the executor, enumerates will at subclause E, and therefore you may or may not register the will. It totally depends upon your desire to do so. Another question usually asked is, can I change my will? Yes, you can change your will any number of times. Moreover, you can prepare a new will any number of times. The only thing that you need to take care of, when you are preparing a new will, you will have to mention about the earlier will and make an unequivocal statement that you have revoked the previous will and this is your last will. Now we come to the other requirements of the will. You need to appoint an executor whom you trust, who will obtain the probate of the will by approaching the Honorable Court of Law, as well as thereafter will dispose the properties as per the instructions in the will. You will also need two witnesses who have seen you sign the will and have also signed the will as a witness in your presence. Of course, you also need to sign the will. Now we come to the other aspects. You need to mention your name, your address, and also list all the family members that you have. Then you make a list of all the estate, movable, immovable, in whatever form you have, in greater detail as much as possible. Then you list your debts and liabilities. Then you come to the clauses where you mention as to how you pay off your debts if you have any. Then come to the clauses where you mention as to which family member gets what part of the property. The thing to be remembered at this juncture is that you can mention in your will properties that are self-acquired. You should have the authority to dispose of the property and only those properties can be mentioned in a will. Another thing that I personally advise is that in case where you are leaving the property to a person which is a family member which is far less or lesser than what you're leaving behind for others, then you mention the reason for doing so. This will help while obtaining the probate of the will. And now, since videography is very easy, it is advisable that you videograph the execution of your will and even the drafting of your will, so that the usual objections that the will was obtained under coercion, undue influence and all that stuff would not stand in a court of law once the whole process of preparing the will is videographed. Also, if the person preparing the will is of advanced age and is undergoing any medical treatment, it is advisable the doctor who is treating the executor of the will affixes a certificate to the will which certifies that the person while executing the will was not under any influence of any medicine which would cloud his judgment, and also that he was in a sound state of mind and he knew what he was doing. That would also help while obtaining the probate of the will. These are some of the questions that are answered. Even though this is sufficient to draft a will, it is always advisable that you approach a lawyer to prepare a proper will. Hope this has answered quite a few queries that people have in your mind, and it will help you have a clear picture as to what is required for you to draft your will. Thanks for watching.